The Firm, India's only show on corporate law, tax and audit matters.
Hello and welcome to The Firm. On the show this week, the Supreme Court stands up for free speech, strikes down Section 66A of the IT Act. And can a winning bidder lose the auction? The recent coal auction throws up a twist, ends up in court. Our top story this week. In a landmark judgment, the Supreme Court stood up for free speech. A two-member bench of Justice Chellameswar and Justice Nariman struck down Section 66A of the IT Act as unconstitutional and reassured the nation that the right to freedom of speech and expression is sacred and paramount. But as Payaswini Upadhyay reports, this is only half the battle won.
It was the winter of 2008. On December 22nd, an otherwise slow-moving parliament showed great efficiency when it passed 8 bills in less than 15 minutes. One of those bills amended the Information Technology Act of 2000 and thus Section 66A was born, with no discussion or debate on the reasons or consequences of the amendment. The genesis of Section 66A can be traced back to the 2007 Parliamentary Standing Committee chaired by MP and former Delhi Police Commissioner Nikhil Kumar. The committee wanted the government to address the issue of spam emails. In response, the Department of Information Technology drafted Section 66A. The committee wasn't convinced, but it let the section be.
You'll see that the purpose of this amendment was to tackle very specific internet-related offences like identity theft, phishing, spam, cyberbullying and so on. But of course the drafting was so poor that over time it evolved into something totally different.
There is some indication that the terminology used in the section is similar to the terminology used in the UK Post Office Act, both of 1953 and then their Telecommunications Act of 2003. We have not used exactly the same language, but I also presume that there was some sort of a reaction of Parliament to cases of misuse or exploitation of electronic media to cause injury, and I think this must have been a reaction to cases such as those.
The poorly drafted and hurriedly passed Section 66A prescribes 3 years of imprisonment for a person who sends information that is grossly offensive and messages that are likely to cause annoyance, inconvenience, danger, obstruction, insult, etc. via a computer or communication device. A legal provision meant to deal with spam email became a menace against free speech. In the last few years, 66A has been used to silence tweets, Facebook likes, cartoons and comedy. It was used to arrest 2 girls criticizing the Bal Thackeray funeral procession for causing a traffic jam.
It was not intentionally or with abuse of one or against anyone. It was just a point of view.
It was used to arrest a businessman for tweeting against a minister's son.
Certainly, I don't think I need to be arrested for tweeting. I have not used any foul language, or I have not abused anybody, and I have not done any comments that is anti-national.
Soon after the arrest of the Palghar girls, 21-year-old Delhi law student Shreya Singhal filed a petition in the Supreme Court arguing that Section 66A violates freedom of speech guaranteed by Article 19 in the Constitution. After almost 3 years, the Supreme Court agreed with Singhal and 8 others who fought the battle with her.
They've upheld the rights of the citizens today because the internet is so far-reaching and so many people use it that it is very important for us to protect this right today.
देखिए आज तो मैं बहुत खुश फील कर रही हूँ कि मुझे ऐसा लग रहा है कि 2 साल के बाद जस्टिस मिला है हमें.
The apex court held that expressions such as grossly offensive or menacing used in Section 66A are so vague that there is no manageable standard against which an offence can be measured. Emphasizing on the chilling effect this could have on free speech, the Supreme Court held that Section 66A arbitrarily, excessively and disproportionately invades the right of free speech and upsets the balance between such right and the reasonable restrictions that may be imposed on such right.
To my mind, really important because it upholds the right of the citizen to know, and it says so at one point, and it upholds the right of the individual to put out his information or his freedom of expression on the net, a facility not available a few years ago. Usually freedom of speech was thought of in terms of the media or a more public expression like at a public meeting. But here every individual citizen now has the right to go on the net and to express himself or herself freely. And I think that's the most important thing this judgment has done.
It's been a week of celebrations for those who braved arrests and those who fought in court for our freedom of speech. But before you uncork the bubbly, remember this. The Supreme Court has paved the way for a new 66A. It has also upheld Section 79, thus allowing intermediaries such as internet service providers and websites to take down content. And this battle does not extend to several Indian Penal Code provisions that do exactly the same as 66A.
In the Shreya Singhal case, one of the arguments by the petitioners was that a new medium like the internet did not need new laws, as the laws to moderate freedom of speech already existed. The Supreme Court disagreed, paving the way for a new Section 66A. But in drafting it, the government will have to heed this judgment and the distinction it makes between advocacy and incitement. It says only advocacy which can lead to imminent public disorder can be restricted under Article 19(2) of the Constitution.
Advocacy of subversive ideas in itself cannot be a ground for punishment or restriction. Only when that rises to the level of incitement can it be so punished. And in doing that, the court ensures that mere ideas, thoughts cannot be punished. There must be a close proximity between your speech and the evil that the government wants to curtail.
The idea behind the Supreme Court was to draw a distinction between what may be, what can be considered and protected by the exceptions in Article 19 and what can't and what should not. And that has been done especially in the context of the internet, which as a medium is unknown, is something which we have never known in the past. It's a medium with the widest amplitude and it has the widest reach as known to mankind till now. And therefore I think it was important for the Supreme Court to lay down these distinctions, and I am hopeful that the government, when and if it chooses to frame a new legislation, will keep these principles in mind, which are very salutary guiding principles.
The Shreya Singhal petition also challenged Section 79 of the Information Technology Act. This section exempts intermediaries like websites and internet service providers from any liability if they take down information used to commit unlawful acts. That meant any complaint could prompt an intermediary to take down information. The Supreme Court has read down the section to say that intermediaries will now be expected to take down information only if a court or government order demands it.
I think the restrictions imposed by 79 as read down are reasonable. A court order obviously has to be followed. But even government orders are important because there are areas of national security, there are areas of incitement to an offense, there are areas of communal or religious incitement where the government must and should intervene swiftly. You can't wait for a court order.
So, the annoying 66A will be rewritten and the inconvenient Section 79 has been read down. But what the Information Technology Act can't do, the Indian Penal Code can. So watch those tweets, Facebook likes, cartoons and roasts. Or you could very well be back in jail.
Section 153A of the Indian Penal Code prohibits spoken or written words that can promote enmity between different groups based on religion, language, etc. It was applied along with Section 66A to arrest the Palghar girls. Stand-up comedy group AIB was booked under Section 292 of the IPC that prohibits selling, distributing, circulating and publicly exhibiting obscene content. Section 298 was used to file an FIR against film director Ram Gopal Verma after he tweeted against Dera Sacha Sauda's leader Gurmeet Ram Rahim Singh.
So far as these provisions which have been held to be constitutionally valid, they are still on the statute book, they are still capable of being used, and in some cases they are still being used. 292 has been used, obscenity has been used, other provisions have been used to prosecute citizens even today, even in the context of electronic communications, electronic records and content on the internet. So that position has not really changed, except that those provisions, unlike 66A, are a lot more specific. Some have been upheld by the Supreme Court.
I think this judgment has to be viewed in a broader context. You have to view it as a judgment that upholds civil liberties as opposed to the tyranny of the majority. And I think that principle will affect a number of provisions, I would hope including the curative petition that has been filed on the judgment under Section 377 of the IPC, and several other matters, because the heart of our Constitution is protection of individual and civil liberties and rights against the will or the tyranny of the majority. And that's why I think this judgment is so important.
In a thin-skinned country full of holy cows, including those of Azam Khan, this judgment reminds the state that it may disapprove of what we say, but it ought to defend to death our right to say it. In Mumbai, Payaswini Upadhyay.
Well, as we said up front, this is only half the battle won. Coming up next on The Firm, can a winning bidder lose the auction? The recent coal auction throws up a twist, ends up in court.